This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. It's Ask Us Anything night, so call in your questions as we're getting ready for the holidays. Maybe you have questions about travel and accidents on the road. If you had an accident in another state, where would you wind up filing that lawsuit? Where do you get a lawyer for that? Maybe you've got questions about presents and the hot products liability issues. There's always something on the market that maybe went to market too soon. The 31 Law Call number, 256-536-0077. You can call in, be live on the air with us tonight, or you can text us to that same number, and we'll have some of your text questions coming up. You can also email us any day of the week. You send your questions to lawcall@waaytv.com, and we pull some out. We'll have some of your email questions tonight for Ask Us Anything night. Will League is here from Timberlake, League and Brooks. Good to have you here.
All right, Sharon, last law call before Santa Claus comes.
Holiday season.
That's right.
We're going to talk about some of the hot products and talk a little bit about product liability and how that works in the legal area. Personal injury cases are what you guys do.
Right.
What all does that cover as we get people calling in and get
You know,
phone
hey,
calls
be brave tonight. Give us a buzz. Ask us anything. 536-0077. You can call or text. Got a question earlier today about fire, about heaters, space heaters.
Yeah.
And I think someone texted in yesterday a question about if someone's injured on your property in a fire, but you did not, responsible for the smoke detectors and fire alarms. So had cases like this in the past. It's a tragic case. You rent a house without a fire alarm. What does the code require? It's going to require some type of fire protection, and that's on the owner. But again, you live there. You invite someone to your home. You have to make sure it's safe for a visitor. Make sure it's safe for you and your family. Now, number one, the text came in that said someone came to my home, space heater started a fire, the fire alarm did not go off, didn't have any batteries, had smoke inhalation, had some damage, but also that your guest was injured. Okay, couple of different layers. Number one, if you rent a home to someone, there's covenants in there that you have to have proper fire protection. Fire alarms, smoke detectors, things like that in accordance with Alabama code in that particular area. All right, so let's say the owner failed to provide that. Well, there's one level of a problem. As a renter, you have an obligation to make sure it's safe for anybody coming on your property, and that injured person has a claim against you and the owner for failure to maintain your premises in a safe manner. And that includes having a smoke detector or fire alarm. You hear it all the time, Sharon. We've had death cases where, a simple space heater, caught fire, but the fire alarm would have warned everyone, and sadly it was out of battery or hadn't been checked. And so there is some liability there. They're sad cases, but you as the renter, you could be liable if you failed to maintain your premises in a safe manner. And not have a fire alarm surely fits that bill in today's, with today's technology.
We've got callers in already, and then let's take a caller first, and then we'll get to our video today. We've got Brandon on the line with a question from Athens. Hi, Brandon. Thanks for calling. Thanks for watching tonight. What's your question?
Yes, ma'am. So now that Robert Kennedy has taken over, or whatever, you know what I mean?
Yep.
And they're going to be outlawing all these chemicals that we've been eating.
Yep.
Is that something you could generally say we could get in a lawsuit over against him?
To stop him, or are you saying we should have done it sooner?
Well, we should have done it sooner, but can we do it now and sue him?
Well, so you're saying should we sue the chemical companies for putting it in our food, or? Okay. All right. Well, there's several. Like for example, our firm's working on a PFAS case.
What is that?
Basically, when you've got chemicals manufactured, the never go away chemical, if you will. It goes into, the water, the groundwater, the drinking water. They're finding materials in our human bodies.
Yep.
In the ocean, in the wildlife, and all that kind of stuff. 3M, DuPont, all those manufacture these chemicals. It's in fire foam, gets in the ground, never goes away.
Okay.
Does that, taint your drinking water? Is it dangerous? And it's like, I think 4 parts per trillion is the amount that can be in the soil or water. And in the case we're working on, it's got severely above those levels. So can you make a claim against the manufacturer? Yes. If they put a dangerous chemical in the stream of commerce and either failed to warn or failed to maintain industry standards for that particular chemical, then the companies can be liable if they knew or should have known that that was a dangerous chemical, A, and B, could it have been manufactured in a more safe manner, and C, if you're going to manufacture this and there is no safer way to do it, you have to warn down the stream of commerce, down the line of stream of commerce, that these are dangerous. So if they failure to warn is an actionable event. And so you can maintain actions against chemical companies for placing these dangerous chemicals in the stream of commerce if there is some type of damage. I know there's a great debate on whether Mr. Kennedy's science background holds muster as to whether or not he knows.
Yeah.
And so that's maybe a bigger debate than we can do here on LawCall. But to answer your question simply, yes, they can be liable if they place an unreasonable, dangerous chemical in the stream of commerce.
It's going to be interesting if a chemical, the government approved it, and
Right.
now the government changes the law. It might be grandfathered in for the cases at the point the government said this amount is legal, this amount is safe enough. If we go changing the law, sometimes that happens. The law changes, and if you did that act beforehand, you may be grandfathered in.
That's right.
Okay.
That's right. I mean, with the FDA and all, they're a watchdog to keep us safe. Now, there's an argument that the present administration is now stripping away those watchdog companies to basically police the big chemical companies, to police Wall Street. 2008, if you guys remember that, we had a horrific, financial crisis. And the regulations, after that, we decided we needed more regulations. And now the current administration, I believe, is stripping away some of those regulations. And so do we need more watchdog groups or do we not? Based on this caller's question, a watchdog group would have helped and trying to curb some of those dangerous chemicals entering the stream of commerce.
It's going to be interesting to see. Brenda, thanks for the question. Very interesting.
Yeah.
We've got Cindy on the line with a question from Section. Hi, Cindy. Thanks for calling. What's your question tonight?
Okay, I was involved in a car accident, and I'm still in a settlement with the lawyer.
Okay.
And am I allowed to ask, like, what amount I would like to have in the settlement?
How does a settlement work? If somebody's a representative, you're a lawyer and you've got a car accident case, and you're trying to work out a settlement, how does somebody like Cindy know whether this is a good deal or what number to take?
Cindy, have you already resolved your case?
No, it's still in settlement.
Okay. So it has not been settled yet. So you can talk with your lawyer about what you think the value of your case is. Oftentimes I'll have clients say, look, I need this or I want that, okay? And then I will talk to my client about the nature of the case, what the damages are in the case. So typically there's a case of negligence, meaning there was a duty, the driver breached that duty by running a red light or something, caused damage, and the proximate cause of running that red light was your damage to either your vehicle or an injury. Based on that damage is related to what the value of your case is, because you're asking ultimately what a jury would think. Let's assume that you had a broken arm and you had surgery on that arm, it cost you $10,000. Well, the jury will typically say, okay, we want to pay that surgery bill and we want to give you something for your broken arm, and if it's not going to work properly in the future, something for that as well. That's the value of your case. Oftentimes you look at the defendant's conduct. And in Alabama, the juries don't know that there is insurance behind every particular driver. And so the lawyer is limited to argue the nature of your broken arm against the defendant driver, and they don't know that there's State Farm, Allstate, Geico, all those guys behind them. And so it matters, unfortunately, who hits you. I understand your arm is just as broke as it was if the little old lady from Bible studies on her way home, sweet little lady,
Right.
Then your case has a lower value. If it's mean old jerk that hits you that the jury won't like, it's a higher value. And that's
interesting.
It's unfortunate because let's say she couldn't use her arm ever again, okay? Yeah. And little old lady on the way home from Bible study didn't mean to hit her.
Right.
But that's a much lower value for that broken arm than it would be if some jerk hit her. And it's sadly, it turns into a popularity contest,
Right.
but it matters about the nature of your injury, the medical bills you have for that injury, and also the defendant, and unfortunately, oftentimes it's a popularity contest.
Yeah. What if-
Because the jury will not know there's insurance, they think that it's you, Mrs. What was her
Cindy.
name? It was Cindy versus Jane Doe.
What if Cindy and her lawyer disagree? Like Cindy feels like what she's being offered is too low, and the lawyer says, you need to take this. You ought to take this.
You know, and each case is different. And so you look at, you want to depend on your attorney to give you a fair value of what he or she thinks your particular case is worth. And it's almost like going to Vegas. There's no legal gambling in Alabama except for jury trials. And oftentimes, you talk to your client, let them know the range you think the case is worth, and then it's a gambling preference, if you will, from the plaintiff to go and ask a jury what they believe the fair value of that particular case is. And there is no right or wrong answer, because you're talking about 12 individuals that have to agree. Sometimes those 12 individuals and jurors are compassionate. Sometimes they don't care and they're mad that they're having to do their duty on jury duty. And so there's so many variables and factors that come in that we say we know, but you only really know once the jury comes back.
Is the choice up to Cindy, or is the choice up to the lawyer, whether to take it or not take it?
The choice is up to Cindy.
Okay.
It's her gambling preference, it's her case, and she can make a call whether or not she can resolve that case. And you want to listen to your attorney, because oftentimes laymen don't know all those variables, and it's very important to listen to your lawyer. I know, I get it, self-serving, but we'll have clients not listen to us, and you've had the same thing.
Sure.
And then we learn the hard way.
Yep.
And you want to try and hopefully you have a good relationship with your lawyer, you trust him or her, and you guys can talk about what a fair value for your particular case is. And shop around, make sure it's a legitimate lawyer that'll try a case if it needs to be tried, will resolve a case if it needs to be resolved, and that's the type of cases that they handle, and they have experience in those particular type cases.
Okay,
That's
we're
very
going to take a
important.
break. We'll be right back. It's Ask Us Anything night, so call in.
Writes Your Calls live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League and Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. It's Ask Us Anything night. Will League is here from Timberlake, League and Brooks. You had something special this week. What is this picture from?
Oh my goodness! So my sweet oldest daughter forced me to run the Rudolph Run on Saturday morning. And that's her right there to my right. And then
Cute.
The Huntsville High soccer team was back there, and they were kind enough to pose a picture with us. So,
fantastic.
So she tired me out Saturday morning going for a run. So if anything, you do anything your kids want to do, right?
I love it. And a shout out, Griffin from Regions Bank had told me he watches the show, and it's awfully nice when somebody says hello and that they enjoy the show. Thank you, Griffin. We appreciate that.
All right, Griffin.
So it's Ask Us Anything night. We've got callers waiting. Michael's on the line with a question from Athens. Hi, Michael. Thanks for calling. What's your question tonight?
Yes. Back in about 1987, I was in a bad car accident, and I was in a coma for a few days. And the accident left me with a bad head concussion and severed my optic nerve and left me blind in my left eye.
Wow.
And my family started a $1 million lawsuit while I was still in the hospital. Well, I got out, and I found out it was a 15-year-old boy driving the car. A witness told me he was combing his hair, and he pulled out in front of me. Well, I was able to drive for 20 years after that, but I've had to quit driving. But the insurance company went bankrupt, and I really didn't get a thing. Can anything be done about that? Can insurance companies be made to have insurance?
Insurance company. Well, so your wreck was in 1987, Michael?
Right.
Yes.
Okay. So the Alabama Department of Insurance will basically police the insurance agencies in Alabama. And you have to have certain qualifications to be an insurer within Alabama, which is a good thing because it protects you, the consumer. If the insurance company goes bankrupt, there's a fund typically that will come in and step in the shoes of the insurance company because all the insurance companies pay into that fund, kind of like a workers' comp situation or something. Poor example, but basically the Alabama Department of Insurance regulates that. If an insurance company goes bankrupt, then the fund can come up and potentially be applied to your particular case. Now, if it's a 15-year-old that hits you, usually 15-year-olds don't, I don't know why 15-year-olds driving in, well, maybe he had his learner's permit. But again, let's say you got a judgment against a 15-year-old. Difficult to collect. If there's no insurance, 15-year-old doesn't have anything, or if he filed bankruptcy, then it's discharged in bankruptcy. All right, and that brings me to a question we've already had tonight, is how do you collect your money from a person after you've been awarded in a civil case without having to pay more money to place liens on their property or assets, okay?
Yeah.
So let's assume this 15-year-old had Green Acre or had assets. Your attorney once you get that particular judgment, then you file that judgment in probate court to put everybody on notice that you have a judgment against this particular defendant. Now, that won't buy coffee because there's nothing to back that up. If that particular defendant has property, you can place a lien on that property and sometimes force the sale of that property to get your particular money out of that. Or you can garnish wages. Now, 15-year-olds typically aren't working unless we're way back in the day, and so you wouldn't be able to garnish wages, especially if it was discharged in bankruptcy. Now, if it's just negligent cases, typically are not discharged in bankruptcy, or I'm sorry, can be. But if you're a drunk driver and you have some intentional conduct, usually those punitive damages associated with that conduct. Again, punitive damages are to punish the wrongdoer and preclude that type of behavior in the future, and so those cannot be bankrupt on. Now, back in '87, statute of limitations run. So for this particular caller, I don't think you're going to be able to go back. In order for the fund to apply to your case, you would have to make that timely claim within that time frame and get a judgment, and then that way the Alabama Department of Insurance, their particular fund, might be able to compensate you based on what you would have been able to recover from the defendant driver. And so unfortunately, I believe your statutes run and it's too much time from then. I understand you had a severed optic nerve, horrible injury, and you were able to drive for a long time, but because your injuries now have gotten worse, you can't go back and reshuffle the check. And that's an important point, that when you sign that release as a plaintiff, that's it. It's like a guillotine falling, and there is no going back and reshuffling the deck, renegotiating your claim. So as attorneys, we want to make sure crystal clear that we know exactly what the nature and extent of our client's injuries are, any doctor's opinions as to the future of those injuries and whether they're permanent or not. So all those things are critical to determine before you sign that release, because once you sign it, that really is that.
Thank you, Michael. We've got Penny on the line with a question from Arab. Hi, Penny. Thanks for calling. What's your question tonight?
Yes, mine's another statute of limitation, but
Okay.
back in 2012, I had aorta femoral bypass. That's where they put a new aorta in from the waist down.
Okay.
Within 2 months, it kinked up, and they said, you're blocked again. There's nothing we can do. Well, after a couple of years, I know there's a statute. I'd done my own investigation, and I got my actual surgery papers of what they'd done during the whole time. The sticker they took off from Central Sterile for the femoral graft had said expired. So
Wow.
I had told my vascular surgeon that. They didn't say anything. He just, looked at my feet, wrote my prescriptions, and that was it. So I've been fighting this for years,
Okay.
trying to figure out, since I found out that the actual graft was expired, is that something I might have a chance at?
Hey, now, so when it was in 2012, Penny, what graft was expired?
My aorta femoral, the
Is it-
whole graft from the waist down, the graft where it tees off.
Okay. Okay. Now, if that was expired and it was not supposed, let's just talk about the case for a second, and then I'll talk about the statute of limitations in a moment. But if the doctor knew or should have known that that particular graft was, I think, expired, is what you said. But again, that particular product must fail on its face for its intended purpose, and it was I think a femoral graft. And so if it fails and they knew or should have known, seems like that would be a breach of the standard of care, okay? And if for a doctor to be guilty of malpractice, they have to breach the applicable standard of care for the particular procedure they're performing on you. So if they bring in an old graft that's expired, if that was the proximate cause of that kink you talked about, it seems like that would breach the standard of care. Now, in Alabama, it's a 2-year statute of limitation, meaning that you have to file a claim with the appropriate court within 2 years of the time of that particular procedure, or 2 years from the time that you discovered it, but in no event longer than, I believe it's 4 years.
Okay.
And so we would have been past that statute of limitation. And so she would have had to file that case. Now, medical malpractice cases are difficult because you have to have a similarly situated physician come in to testify that there's a breach of the standard of care, and oftentimes you have to go outside the state to do that. It's because doctors don't want to testify against other doctors. Don't blame them, it's a small community.
Yeah.
But at the same time, you want a reasonable and truthful and accurate opinion. And I'm just so sorry that that happened to you.
Yeah.
And unfortunately, I think the statutes passed once you got to 2016.
Thank you, Penny. We've got Dan on the line with a question from Madison. Hi, Dan. Thanks for calling. What's your question tonight?
Hi, thanks for taking my call.
Sure.
There's a guy that put a trailer on Limestone Creek out where I live,
Okay.
and the trailer's like 4 feet from the creek. I thought that they had to be a little further away from that, just for pollution
Yeah, would seem.
problems. But he's got his sewer line going from his commode toilet to the creek.
Oh, that's great.
Ooh.
Yeah, and I seem to be the only one that's even remotely concerned about this. I called the police in Athens, and the guy kind of chewed me out, and he told me that the waste treatment plant upstream just dumps that stuff just in the creek. He
That's
said
weird.
just-
That's weird. Is it a municipality? Are we out in the county? What's happening?
Yeah, it's Limestone County. Just
It
out
still
by
seems
Limestone
wrong.
Creek.
They're telling
Yeah.
us we got 30 seconds. So then, first off, I think that's a health violation. Some type of hazard's got to be. I don't think they can just dump waste in the creek. And I'm surprised you have a city employee chewing you out saying they dump it up the river anyway. But I would call the health department. You want to go down, maybe want to go down to Montgomery if you're not getting any help from limestone officials. But I'd call around, and it seems like a health violation to me. I'm no expert on that, but that doesn't sound right.
That doesn't sound right. Thank you. We're going to take a break. We'll be right back. It's Ask Us Anything night. More ahead. 0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And family law attorney Sharon Doviet, 539-7337, SharonFamilyLaw.com. Divorce, child custody, all the important things.
A lot of great calls tonight.
Hey, you know what? Thanks to all the callers. You guys make the show, so thank you for calling in, being brave. We got a lot of funny texts. I appreciate that.
We do.
We got one about social host liability.
Yeah, serving
Can
alcohol
I
at
get
a
everybody
party.
drunk at my house, he says. And you can, but you can be liable for it. If you serve alcohol and you do it contrary to the provisions of law, you serve someone who's already drunk, you could be liable if they go out and hit someone and hurt themselves. So really be careful. It's holiday party season. We get it, but show some restraint. Good luck.
Be safe. Thank you. See you next week.